was in Colorado and West Virginia. And my position there as president, I am an attorney, and also I am a certified mine safety professional. Typically, I represent employers in OSHA and MSHA matters, but I have handled a number of minor whistleblower cases under the Mine Act, where I have been representing the worker against whom discrimination occurred. And I also teach employment and labor law at University of Colorado Boulder and at Catholic University of America in D.C. I am not speaking on behalf of any of those institutions, so I want to make that clear. But having had over 25 years of experience practicing law, including whistleblower retaliation actions and another 10 years beyond that as a safety professional, one thing that has become very clear to me is that many workers do not understand what their rights are. They don't understand what they can and can't report to OSHA, and there is definitely fear of reprisal, fear of reporting the retaliation against themselves, and also fear of reporting retaliation against others. The opposition clause, as the EEOC would look at it, in Title VII, for example, or in testifying against an employer in support of other workers, participation in this. And I think it's vital, I'm going to talk very quickly about training, but as part of that, I think it's very clear to communicate to workers that this is protected activity. It's also critical to make people understand that all workers are protected. This isn't just hourly workers. And indeed, some of the individuals that I've represented have been the safety and health professionals within their companies who, knew about the issues, came to try to effectuate some change, and then were retaliated against or terminated as a result of that. And yet people think if they're on salary for some reason, they don't have any protection under Section 11C of the OSHA Act, and that certainly is not the case. In terms of issues that I hope, I will say I haven't been at all the stakeholder meetings, but just a few things as you look at rebooting perhaps the whistleblower program to put on your dance card. The statute of limitations. Clearly 30 days is almost unconscionably too short. And when you couple that with the fact that there's no mandated training on workers' rights as there is under the Mine Act for new miners, that becomes especially problematic because workers may well blow past the first month without realizing that indeed either they engaged in protected activity or that the action that occurred is adverse action within the scope of Section 11C. Now, OSHA did remedy the situation in part under the electronic record-keeping rule, where the statute of limitations effectively was expanded to 180 days. But again, I think most people think that those protections are really limited to retaliation that arises as a result of reporting an injury or an illness. And OSHA should make clear that anything that would be protected under Section 11C can also be reported to OSHA under Part 1904.36, which would then lend that 180-day statute of limitations without the need for a statutory amendment. In addition, they should make clear that the relief where the sanctions under Part 1904 more specifically are not limited to fining the employer $134,937 if it's a local violation, but would include as abatement make-whole relief, including restoration of employment and back pay if there was a loss of pay, etc., seniority or other benefits. Going forward, I think if OSHA isn't going to mandate it, which I'm sure right now they're not going to through a rule, there should at least be more encouragement that there be expanded training on workers' rights. Part 1904.35 requires training on the right to report injuries and illnesses without reprisal, but it does not require training on the whole spectrum of protected rights under Section 11C, and that is something that OSHA could encourage. One of the questions that Deputy Assistant Secretary Smith had posed is how can OSHA better deliver customer service on this? I'm going to keep saying, look to MSHA because they've been having mandated training on this for years, and they have a lot of support materials on their website, including some pretty good videos on the whole issue of how to report it. A case of retaliation, but also on recognizing what is unlawful retaliation for protected safety activity. And going forward, OSHA and MSHA are sister agencies. There's really no reason why there couldn't be some pooling of resources because retaliation occurs across both sectors. I will note, yes.
We're over for time, and I really like the comments that you're making, so remember we have some time available at the end for additional comments.
Okay. If I could just wrap up with one final question. You had asked, were there any particular issues in healthcare or retail? And I will note workplace violence and reporting of such, protection from such, that is critical. It's the number one cause of death for women in the workplace, and the disproportionate number of those fatalities occur in healthcare, social services, and also in retail. So thank you very much for your consideration.
Thank you very much, Adele. Operator, do we have a Kathleen Wakalowski?
Please press star 1, Kathleen, please. Again, please dial star 1 to be notified.
Okay, operator, we'll go ahead and move on to the next person, and if, as we get her later, we'll try to work her back in. Do we have Danielle Marcena?
Okay, let me check here, find out for you, and just for future reference here, once your name is called, if you could just press star 1 to be notified.
Not hearing anybody. How about we'll try again. Next person, operator, do we have Abdurazak Pottery?
And if your name was called, could you please dial star 1 to be notified? Okay, so we have a couple people that has dialed star 1, but they're not the names that you had listed. Did you want me to?
We'll keep going down the list if we can. We'll just take one at a time. Let me try Robert.
Well, every question is just, I'm sorry to interrupt, but everybody that responds during the Q&A are only going to be the individuals. It's not going to be collective. It's only going to be one person at a time.
Correct. So we can only call him one at a time. So we'll try. May I try another person?
Yes, sir.
Okay. Mr. Robert Mills?
Ah, okay. Pausing.
Your line is now active. Thank you. All right, good morning. I'd again like to thank OSHA for offering this, and as an EH professional of 15 years with a primary background in industrial hygiene, but working in the manufacturing sector, now building space components here in California for the last 2.5 years. I see the whistleblower program is the end of the line, and that OSHA should do more to enhance its business assistance unit. Having been on the regulatory side working for a local CUPA for several years, I understand how businesses are very reticent to want to embrace the enforcement individuals or those who are looking to create compliance within their business when they think that just a hammer is going to fall on them. I have had a very difficult opportunity, and many times that I feel comfortable bringing in a Cal OSHA business representative, but management thinks I'm losing my mind, and they question why I would want to do such a thing. And having been on the regulatory side of things, I understand that if a business wants if they want me to come out and help, I'm not there to fight them. I'm there to assist them, right? I'm there to the fact that they want compliance and they want to move to that next level, not just being compliant, but, what should we be doing to better assist our employees? And as an EHS, that is my goal every time is to not do the minimum, but what is the best practice, and always looking to raise our bar. The one thing that I have had a very difficult time finding, though, is videos and other sorts of information that I can educate our management on to show them that, look, that OSHA has a side that is not regulatory, but is assistance. And I would love to see OSHA do more in the ways of that. I think it would really assist their whistleblower protection program, having a better outreach for their business assistance unit. It would also bring a greater compliance for the law and the TED to have a safer work site. And that's all that I have.
Well, thank you very much, James. Appreciate it. Operator, do we have a Michael Wizik?
Michael, would you dial *1, please, to be notified? Michael Wizik, your line is now open.
Okay, thank you very much. I do appreciate this time to being able to bring up some of the constructive criticisms, and then also just overview of the whistleblower program as it stands, and to potentially share some insight from industry. I work within food manufacturing sector, and it is my pride to bring health and safety programs to within that industry. Currently, I'm overseeing 13 sites, many of which were recently acquired and have very little safety protocol, and we're in charge of upgrading those systems. One of the critiques of the whistleblower program is that it typically applies to organizations that are already in process of adapting, changing, and growing. And it usually comes out of addressing OSHA 10, OSHA 40s with employees and letting them know that they have that ability to report. And what I've seen is that often, especially when concluding acquisitions, that as soon as you have the ability to deal with health and safety issues through other avenues, that they're also aware that they have the avenue to use OSHA as a whistleblower. And that's a very positive thing in a lot of ways, but usually it's somewhat retroactive. And it's often associated with the employee being disgruntled after years of work, but then also that employee maybe feels that during acquisition their job is less stable than it would be in a normal time, and would like to have some level of protection on those. Out of all the whistleblower complaints that had to work through, I can tell you that most of them had merit. There was only a few that were completely outside of the bounds of normal operation. But all of them were from employees that were disgruntled about actions that had happened in the past and not actions that were taking place currently or scheduled for future operations. And it was this kind of interesting juxtaposition to Adele's opinions that we should increase those protection timelines. I don't think that they should be decreased, but I did want to add in that the perspective from employers can be slightly different on that. If the systems are already in place to fix the issue, does it make sense to extend those protections further, specifically if an employee is utilizing it in a way outside of the normal bounds? Then secondly, I wanted to address with a similar concern to James Quinley, that we don't have the services out in the field that are getting the word out that employees do have these protections, these low protections. And so usually where it does hit is organizations that are educating their employees on the whistleblower programs. And those are usually the ones also with a better protection for the employees. So often we're seeing this kind of strange interaction that the problem as a whole is left unnoticed. It continues to fester and nobody is notified. But if positive actions are taken, then that's when the employees feel more boldened and empowered to take these actions within the whistleblower program. And also often they don't want to have, they usually don't want to get anybody in trouble. They're just looking for an outlet and don't quite trust whoever's directly representing them. Okay, then the part that I wanted to bring up is information availability. I think that where we're at currently, information on whistleblower complaints is a little bit difficult to find out exactly what the complaints are, particularly within the industry. And I understand that there needs to be some level of anonymity, and I believe that that should be cross-utilized in a similar fashion to other whistleblower programs, where the anonymity of the person filing complaint can be maintained. However, I think that the information surrounding the complaint should be publicly available, made available to all people within the industry and outside of, so we can learn from others' issues and mistakes and adapt. Thank you.
Thank you very much, Michael. Operator, do we have a Rudy Capella?
Rudy Capella, could you please dial *1? Rudy Capella, could you please dial *1 to be identified?
Operator, we have Carolyn Noble.
Also dial *1 to be identified here.
Operator, do we have a Mohammed Sharif?
Sharif would need to dial *1 to be identified.
Operator, do we have Abdullah Ali Bakawi? I'll say that again. It's Abdul Jalali Bakawi.
And it's my apologies. But I want to be identified.
Operator, do we have a Steve Salmon?
Nobody's on here.
Steve Salmon, your line is now active.
Thank you. And thank you for the opportunity to speak today. My name is Steve Salmon. I'm the Assistant Director of the United Steelworkers Health, Safety, and Environment Department. We express our sincere appreciation for the OSHA career staff and for all they're doing in these unprecedented times. Given the lack of leadership from the Trump administration, your work is even more important. Due to time limitations, I will not get into the general problems workers face around reporting of work-related injuries and illnesses, disciplinary measures with the vague rules, incentive programs and drug testing that create what we call the bloody pocket syndrome, not to mention the problems with the 30-day deadline to file an 11C complaint, and OSHA administering more than 20 whistleblower statutes with varying time limits for filing. Instead, I'd like to start with OSHA's understaffing issues, and this certainly applies to the staff who handle whistleblower cases as outlined in the recent Office of Inspector General's report. Whistleblower staff already had a heavy workload prior to the pandemic, and now, like the pandemic, 11C complaints are out of control. The Trump administration is not only failing in handling the pandemic, but also protecting workers who file complaints with OSHA. Workers must be able to report hazards and be involved in safety activities without putting their jobs at risk. While legal rights should, but often do not, protect workers refusing unsafe work, no one should have to choose between their job, their life, or their family members' lives being at risk of bringing the virus home from work. The meatpacking industry is just one example. On April 8th, OSHA issued a news release. The U.S. Department of Labor reminds employers that they cannot retaliate against workers reporting unsafe conditions during coronavirus pandemic. But it has done little to give workers any confidence that the agency is still there to support them. Employers know that it is only a small chance of being punished for breaking the law that protects whistleblowers. And even when employers are caught, the penalty is usually light. I would strongly encourage everyone to go to the National Employment Law Project's website at www.nelp.org to see their October 8th news release. OSHA investigated, resolved only 2% of COVID retaliation complaints, and the report, OSHA must protect COVID whistleblowers who file retaliation complaints. NELP analyzed OSHA's public data showing 1,744 COVID-19 related retaliation complaints filed by workers from April through August 9 and found 1 in 5 complaints, or 348, were docketed for investigation. Only 2% of the complaints, 35, were resolved during that period. Most complaints, 54%, were dismissed or closed without investigation. On October 12th, the Huffington Post posted on their webpage, "Workers tried to blow the whistle on COVID-19 hazards. Then people died," by Dave Jameson. A new analysis shows that a spike in complaints to OSHA precedes a spike in COVID deaths. In closing, OSHA and the whistleblower protection programs are important, critical for workers, but OSHA needs staffed, an administration who is willing to support it, and the law is strengthened. Workers have a significant role in advocating for their own safety. The Occupational Safety and Health Act acknowledges this. OSHA must do its part to ensure that safe workplaces, protect workers who raise safety concerns and for exercising their rights as an employee under the whistleblower protection laws enforced by OSHA. Thank you.
Thank you very much, Steve. Operator, do we have Olinda Martinez?
Please dial star 1 to be identified.
Operator, do we have a Tommy 9?
Please dial star 1 to be identified.
Operator, do we have a Rich Hoffman?
Please dial star 1 to be identified.
Yes. Hang on a second.
After the tone, please state your name.
Rich Hoffman.
Thank you.
Hello, can you hear me?
Mr. Huffman has dialed in. Would you like to take that question?
I do. Thank you.
Mr. Huffman, your line is now active.
Yeah, my name is Rich. I'm more of a victim than anything else. I'm a safety compliance manager for 10 different facilities based out of the Central Oregon area, and I've been directly involved maintaining my my staff members to ensure that they're not ever going to have to process or experience what I've had to. I'm trying to stay within the ground rules, and I've been able to publish everything that I've dealt with personally online. And I have 2 separate computers, and I was trying to record this through the UCAM process. I reached over to my other computer, and there was somebody going through all my files. And this concerns me because I lost one career when I was 25 because I exposed an incredible, burn injury risk with my employer. And then I had, that was in 1986. And again, in the year 2000, when I was a fire captain working for another state agency, I discovered on day 3 a severe Fair Labor Standard Act violation in regards to the maximum 28-day cycle for any time frame to calculate hourly wage. Hourly rate was extended to 30 or 31, and 9 shifts a month times 12 is not the same thing as 9 shifts a month times 13 cycles a year, and it resulted in a huge pay increase for the hours that we were there and gave us an additional 216 hours off every year. And I went through incredible on-site retaliation from my coworkers who happened to be the author and co-author of this, as they were the affiliate president and vice president of my position for representing all the fire captains within my employer, and only 120 of us statewide throughout 34 different facilities. And anyway, so I was finding poison on duty, and then I went through a process of where I had an attorney that represented me, one of the top 10 workman's comp attorneys in California. And 2 weeks before my hearing, he said, yes, we filed, within the 20 days, whatever it was, how much we wanted. He said, Rich, we're asking for $3 million. I'm going to get 12% at 360, at least $2.64 million. and that was 2 weeks before. Now I'm a twice patent inventor. I'm an owner of my own company, HFT Fire and Rescue Technologies. Um, um, Through the process of what I've gone through has inspired me to write a book. Okay, it's poorly written at this point, but it's more of a research manual on how to properly calculate hydraulics, and it's inspired me to to push forward and rise above, and there's no better way to prepare a leader than to go through a boot camp, far worse than anybody else could possibly imagine. But anyway, a week before my hearing in the year 2000, because I have my first patent already filed, and I was thinking I'm going to have all the resources I need to move forward on this incredible hose roller that I invented, plus a hose deployment method that Texas A&M has been teaching since 2006 when high-speed internet was finally available. Yeah, the dean of students said I was the first firefighter representing millions of firefighters to do what they never thought was possible, let alone video demonstrated. And that's at off my website as well. Anyway, the point is that a week before my hearing in 2000, my attorney said, "Mr. Hoffman, we reconsidered. You'll be lucky to get 30,000. That's 1%, 1% of what I was going to get in 7 days earlier. And he's going to get 12% of what? He's going to get, do the math. Okay, 3,600. This is one of the top 10 workman's comp attorneys in California. He would not even take in a case of such low magnitude to make it worth his time for 3,600. And when I asked him on the phone, I said, because this involves the direct felony embezzlement of federal public funding, because there's a portion of the state of California budget is federal funding that they got to you, and he hung up on me. Why? Because if he represented me, he would be randomly killed in a random drunk driver versus his vehicle accident into the driver's door at 90 miles an hour. And literally, we're talking, when I was trying to get my computer up, there was somebody in my computer. Welcome to the internet. Okay. And the files that I have are incredibly incriminating for two separate state agencies that, that are going to be, um, yeah. Anyway, so I'm just here to. I did file a Cal OSHA complaint, and
Rich?
yes,
Rich?
go ahead.
Rich, okay, we're over time.
Thank you much.
We lost time at the end.
Thank you, sir.
Make additional comments, okay?
Thank you very much. I appreciate it.
You're welcome. Operator, can we retry Brian Walker?
Please dial star 1 to be identified.
All of it?
Operator, do we have Justin Edwards?
Justin Edwards, please dial star 1 to be identified.
Operator, do we have Mark Witzke?
We do not have Mark Whiskey, but we do have Justin Edwards available, so I take that.
Yes, thank you.
Edwards, your line is now active.
All right, thank you. I'm actually a compliance chief of compliance for my company here, and one of the biggest things I think that we have to do from the employer side is we have to educate the employees. For a few of the other individuals who have spoken, talk about getting the information out to the employees, because I think in any industry, doesn't matter if you're in healthcare, food packing, even government industry, knowledge by a few is never good, especially when it's, public knowledge. It should be handled for all employees. So I think one of the biggest issues from there is educating. And that's where I really focus. I've been a training manager for the majority of my career, and I always train employees on, A, you've got a voice, and B, this isn't high school anymore. I train a lot of them on see something, say something. This
isn't a situation where we're focusing on reputations and, well, I've got this person's back or so forth and so on. And it's a pretty tough wall area to break down a lot of times, especially coming into an industry where there could be, years upon years of everybody will sweep that safety concern up under the rug. Nobody cares. It's not going to go there. And it begins to be kind of, well, that's the way we always did it, so why should we change anything? That's a tough dynamic to change, and it requires a culture change. So I'm just enjoying kind of listening, but my comments to that would be just to make sure for employers that are listening, the more you educate your employees, the better off you'll be. And never be ashamed to ask for help from an agency like OSHA or MSHA. There's always training material that's available, and knowledge on the front end always equals less of a headache on the back end. Thank you.
Thank you for your comments. Operator, can we try again? Mark Witzke.
Mark Witzke, your line is now active. Thank you. My name is Mark Witzke. I'm a rail labor attorney out on the East Coast, and also a member of a group called the Academy of Rail Labor Attorneys, behind and with the tutelage of another gentleman who's going to speak in a bit, Lawrence Mann, is sort of a newcomer to having whistleblower protection. In 2008, Congress saw fit to pass the whistleblower amendments to the Federal Rail Safety Act, 49 U.S.C. 20109, and it brought, I think, an incredibly bright light to a very dark path. What we had was railroads running around unfettered in terms of their reactions to reported employee injuries, and a drastic undercount as a result of the number and extent of injuries to employees. And so it has been a steep learning curve for those of us who were used to having to just accept the lumps that came with opening your mouth about safety. What we have come to learn since then is that the forces are still at work to clamp down on the protections that were written into the statute. Specifically, what we've seen is the courts, in particular, are creatures of habit and have been reading Title VII retaliation, burden shifting, Donald Douglas into 49 U.S.C. 20109 protections. And by its pure statute, it's clear, I should say by its pure text, it's clearly not intended to be there. But the courts have had a tough time believing that anybody would give railroad workers the kind of protections that the statute does. So I would ask that OSHA consider making it explicit either through text or at minimum commentary, making it explicit that this is not intended to pull into it in a legal vacuum the idea of the burden shift. Secondly, there is an ongoing interpretation that the reporting of a safety condition and separately that following the treating doctor's treatment plan, the protections that come from that can only be for an incident that occurred on the job. This, of course, makes no sense because when you take a narcotic medication and it affects your safety, because the narcotic has no idea whether the underlying condition was work-related or not. The protected activity is reporting that it affects your ability to be safe. So a safety-sensitive position it's important to be able to open your mouth without retribution. This has come up in a couple of different scenarios, including one with a Long Island Railroad locomotive engineer who reported that he had been taking narcotic prescription pain medications in relation to a dental procedure, and he was penalized and put on the street, which is railroad lingo for suspended without pay. But the court found that it was irrelevant and it didn't fall within protections of 20109 because it wasn't from an underlying on-the-job incident. More or less, I'd love to say thank you to OSHA for implementing it and like to recognize that they need far more investigators to
actually follow through, because I think they ended up with a lot more folks than they ever anticipated making use of the statute. Thank you.
Thank you very much. Operator, do we have Ed Stern?
Ed Stern, if you could press star once we identify.
Operator, do we have Larry Mann?
Your line is now active.
Oh, okay. Oh, hello. Can you hear me all right? I hear you fine, Ed. Go ahead.
Okay. I join with the others in thanking OSHA for having this meeting to get public input. I think that's very valuable. I'll try to be quick. I have already submitted written comments on the need to polish up some definitions of intimidation and harassment. You have it, that is to say, you have intimidation and harassment under retaliation, but for my own research, and over the last more than 12 years, and looking into workplace harassment and writing on this, particularly since retirement in many occupational safety and health and also HR magazines, and advising some federal agencies, it's pretty clear, and state, it's pretty clear that some people just don't understand what that means, and they tend to think of it as only physical violence instead of psychological violence, which is often the way it's expressed in retaliation. So I've given you notes, and I've particularly pointed to, with regard to polishing up, explaining these things, I pointed to the Department of Labor's Workplace Violence Program, which probably people don't know enough about, to the NIH Civil Workplace Violence Program, to the state of Tennessee Model Plan on Abusive Conduct. That's excellent. All of these are very good, and I attached links to a couple of my articles, just a few articles on this that I thought were particularly relevant. After doing that, it occurred to me that really there's another way that you could help the workers who are covered by the whistleblower laws, and for that reason, and I didn't write about it, I suggest that you could provide your audience, as people who need your help, with a kind of interactive expert help that OSHA and the U.S. Department of Labor have provided the business community for some years. OSHA started looking into doing this with funds in the George Herbert Walker Bush administration. That's a long time ago. And by the time we had OSHA online on the internet, somewhere around 1994, 95, we already had tools to help people understand some very complicated rules on asbestos and cadmium. And I met with then we had Director of Standards, Health Standards, Safety Standards, and Policy. We sat down, and since we had done 2 on biological monitoring and so forth, the Director of Safety Standards said, it's my turn to pick, and I want you to do confined spaces. And I want to tell you that I told the guy, since I was supervising regulatory analysis, a group of economists in regulatory analysis, I said, I think that rule is so easy and so straightforward that you really don't need interactive diagnostic help that will interview people and help them figure out what they. And he said to me, Edward, you've been doing this for 20 years, actually, it was 25 years by that time, and he said, it's easy for you, but it's not easy for the people who are reading this. And so we went ahead and did the Confined Spaces Advisory around 1997 or something like that. And it was very popular. And I want to tell you, their problem was much easier than what you have. I would say yours is more equivalent to the problems, the complexity in the record-keeping rules, maybe even more complex. And we finally got a record-keeping advisor out somewhere, I think, 2011, because after that I did the cadmium advisor, the big broad cadmium advisor, which is very complicated. But I strongly suggest that you look at the Confined Spaces Advisor and the OSHA Record Keeping Advisor. Although these are OSHA tools and developed by OSHA with the Solicitor's Office and the staff and the experts on this, they sit on the dol.gov/elaws, ELAWS site, because the Department of Labor then picked up our models and used them to develop other tools for the other agencies of DOL, with the guidance from the Office of the Assistant Secretary for Policy. As a matter of fact, that's Assistant Ask did the programming for the last couple that I did. So I think you could deliver this kind of interactive help, and basically it's to hold people's hands as you walk them through very complicated stuff.
Go.
So that would be my suggestion. I may have other suggestions for you all. I think that would be my buzzer.
That was your buzzer. Thank you very much. Operator, do we have Lawrence Mann, Larry Mann?
Lawrence Mann, your line is now active.
Thank you. I was involved with the enactment of the railroad whistleblower law back in 2008, and subsequently, I was a member of the Railroad Advisory Working Group to the Whistleblower Protection Advisory Committee, and so I've been involved in the railroad whistleblower law and its application for its beginning of the law. I'm counsel to the Academy of Rail Labor Attorneys. This is the nationwide organization of lawyers who represent the railroad workers in whistleblower cases. I just want to emphasize that the railroad workers do not know their rights. They are fear of reporting. There's no training by the railroads of this issue, and that needs to be implemented somehow. I submitted to the Whistleblower Protection Advisory Committee on May 3rd, 2016, of major problems that existed in the implementation of the railroad whistleblower law. I'm not going to take your time, to go through this. I would like to just submit that letter to the record, today's record, and at your convenience, you can review what my comments were. Thank you very much.
Thank you, Larry. Operator, do we have April Dickerson?
Star 1 to be identified.
That's good.
April Dickerson, your line is now active.
Hello, and thank you for taking the comment. I am a safety professional in the healthcare industry, and I really do feel that our company has a very strong safety program, and we've always encouraged our employees to speak with their immediate supervisor or to jump to a higher level manager if they feel something's unsafe. We even have a compliance hotline where issues can be reported anonymously with postings with that hotline number posted up throughout our workplaces. However, my company has been reported to OSHA on a few occasions when nobody has even hinted to a supervisor that they felt there was an unsafe working condition, which I do understand is their right to do so. Luckily, our company has never been fined because we were always able to prove that there either was no hazard in the first place or that the unexpected hazard, for example, a plumbing leak, had already been quickly addressed and resolved. At these particular locations where we were reported, we have known employees who are repeatedly problematic with other labor unrelated issues, and we feel that we've been reported as some form of revenge, so ultimately retaliation in reverse, which costs us time and resources to prepare lengthy responses to defend ourselves against these false allegations of unsafe workplaces. I can personally attest that it's taken me over 8 hours to prepare a 200-page response related specifically to a coronavirus allegation, which documented all of the employee communications, policies and procedures, the postings and trainings that were put in place to help keep our employees and patients safe. My comment for OSHA is, please ask employees filing complaints if they have even bothered to notify their allegedly unsafe working conditions to their manager and what their manager did in response to that. And if they did not report the hazard to somebody in their company, please encourage them to report alleged unsafe conditions so that the company has a chance to respond to that. This will lead to much quicker resolution of actual hazards in lieu of waiting for OSHA to get around to notifying the business of a hazardous condition complaint before it even begins to be addressed. While we are happy to respond regarding actual hazards, and I do realize that the people taking these OSHA complaints don't know if a hazard actually exists or not when one is reported by an employee, I do find it rather annoying to be the recipient of employee retaliation regarding hazards that don't even exist. Thank you.
Operator, do we have Sean McKinley?
Is now star one to be identified?
Okay. Operator, we have Jeremiah Miller.
Is now star one to be identified as well?
Okay, everyone, we've reached the end of the list, the first run through the list. I'm going to go ahead and try to recall all the folks that registered to speak that we weren't able to reach. And then after that, we will go ahead and open it up for additional questions. Kathleen Wakolowski. And reminder, dial star one if I call your name. Danielle Barcena. Abdurrazak Bari.
We have a question coming in here. Let's see.
Who it is.
Danielle, your line is now active.
Hi, good morning, good afternoon. Can you hear me okay?
I can, Danielle. Thank you.
Okay, great. Yeah, thank you very much, Mr. Swick and Ms. Sweat, for having me and all the other speakers today. I just wanted to talk from the perspective of an employee today. I was an employee at, I'm not going to get into the specific details here. I was an employee who raised concerns about the COVID-19 pandemic. And this was in March. And those concerns ultimately got me to the point where I no longer work at the company that I was working at. And what happened was none of the issues were addressed. And my removal set an example to other employees to tell them that it's not safe to bring concerns about safety and health forward. And I know that the COVID-19 pandemic has, it came so abruptly and everyone is doing their best to catch up to figure out how to respond. But we're still in this emergency situation where we have this highly contagious and deadly virus going around. And, we're seeing countless complaints being raised and complaints being closed, really with no meaningful action taking place. And I know that, I know the people I've worked with at OSHA to handle my complaints have been very kind to me, and they're doing what they can with what they can. But I feel that there's a disparity between sort of knowing your rights and then being able to have your rights of a safe workplace. OSHA does a really good job of telling employees and employers what their rights and responsibilities are. I know that OSHA has a lot of programs to educate employers generally, but when complaints are not taken seriously, it really diminishes the right, I guess, to a safe workplace. And the risk for whistleblowers to come forward really doesn't hold any weight if those complaints are not investigated or actions are not taken. I guess I just want to point out, OSHA proactively publishes a FOIA log of closed complaints and for COVID-19. And we see the same complaints from really all employees saying that employers are not providing PPE, they're not social distancing, they're not informing employees that their coworkers have tested positive and they've been exposed. And this is everywhere. And so I guess I'm just concerned that the lack of seriousness for the complaints being raised really affect, the effectiveness of blowing the whistle at all sort of loses its weight. So maybe there's something to be done there. I guess that's it. Thank you.
Thank you very much for your comment. William Medley? Rudy Capello? Remember, star one if I call your name. Carolyn Noble? Linda Martinez? Tommy Anine? Brian Walker? Jeremiah Miller? Okay, at this time, if anybody else has additional comments, let the operator know and start one. After the tone, please state your name.
Rich Hoffman.
Thank you. I'm sorry, can you say your name, miss?
My name is Rich Hoffman.
Valerie?
So,
Valerie, you might be on mute.
Okay. Our next question comes from Brandon Fields. Your line is now active.
Thank you. Good morning, good afternoon, everyone. My name is Brandon Fields. I'm actually a safety compliance officer with the state OSHA program up here in Alaska. Not only that, I'm a trained whistleblower investigator and was running our whistleblower program for a little while. And coming from the regulatory point of view and from a state plan versus the federal OSHA viewpoint, I can say that we share a lot of the same challenges that OSHA has, with the exception that our state plan only has to investigate violations affecting respectively, of Section 11C, our equivalent state statute. What really struck me in going through the initial whistleblower training, which I did some years ago, is the volume of the cases that is assigned to the whistleblower investigators at the federal level is massive and growing more by the day as more statutes get added. And that's one of the primary issues that I see across the board with whistleblower is resources being devoted to an increasing workload. In these cases, I can tell you from personal experience, are rarely, if ever, easy or quick to resolve. These investigations can be extremely extensive. There's lots and lots of interviews, and they almost never have any kind of direct documentary evidence. It's almost always through and things like that. So they take a long time to develop, and the longer that you take to develop these cases, the longer that the complainants, the victims in these cases are going without their restitution, which then goes further into the idea that employees have rights, but these rights are enforced in a way that doesn't make it worth them engaging in them. If it takes multiple years for a whistleblower investigation to make somebody whole, then what have they lost in the meantime? I've had multiple employees tell me to my face, as not only a safety compliance officer, but a whistleblower investigator, that it's not worth it to them to make a complaint because it's going to take too long and we can't do anything about it fast enough. So the only way that this is even possible to happen is by dedicating more resources at both the national and the state level to whistleblower investigations. And I think that obviously from a national policy level, OSHA only has so much control, which is why I wanted to put this on the public to say that I think that it's important to get more resources in the whistleblower program, so that that can also trickle down to the states, because as anybody who's familiar with state plans knows, that states are required to be at least as effective as federal OSHA. Well, right now it's difficult for OSHA to tell any state that its whistleblower program is not being effective with it also struggling to meet basic requirements of whistleblower investigation. So that seems to be one of the paramount issues that I have seen from a professional perspective, and even trying to do these investigations in my dealings with regional personnel.
Thank you for the comments, Brandon. Operator, anybody else?
Our next question comes from Pam Saline. Your line is live.
Yeah, mine's just more of a comment. I dealt with mold in the workplace in a water damaged building that was over 100 years old and wouldn't be accommodated, and had worse health issues, going on over 6 months, doctor's notes, lots of documentation, and ultimately now have underlying health conditions I didn't have prior to working there, because OSHA's response was just find another job during my complaints of these allegations, and the owner's response was just, or the company's response, I was just stonewalled constantly, and almost felt like maybe I was one of many that was sensitive to the biological contaminants in that building, and simply at the end was to have long-term terminated, and it all felt kind of orchestrated. So now I'm going through the whistleblower process. I don't know what will come of it, but I didn't want this situation to happen to anybody else, so I did create a petition to strengthen Title 8, so that it wasn't really just a mere calculation on does it cost more to remediate, or is there more of a possible financial benefit with just getting rid of an employee wrongfully terminated, and hopefully nothing comes of it, because not everybody is sensitive. And I felt that's basically how my employment was ended, was basically on a mathematical risk calculation. So anyways, my petition is scheduled to be denied for more measures when somebody voices being sick in a building, for possible testing and to see if remediation is necessary. So that's basically it. That's where I'm at now. Still in the whistleblower investigation process. Don't know what will come of it. Not a fun process, especially during this time and what's going on with everything else in the world. And that's it.
I'm sorry, I kind of just missed your name. Can you say it again?
Pam Sailing.
Can you spell the last name? I'm having a hard time understanding it.
Sailing.
Thank you so much. Operator, anyone else?
Yes. Can you hear me? This is Adele Abrams.
Hi, Adele. Welcome back. I knew you'd be here.
I hung on to the bitter end, and I appreciate being able to double dip here again for the record. My name is Adele Abrams. I'm the president of the law office of Adele L. Abrams, PC, and I am a safety and employment attorney and also a safety professional. I had already spoken to some extent about looking to the Mine Safety and Health Administration, perhaps for guidance on ways that OSHA could improve its delivery of services to the regulated community, because MSHA has been a lot more aggressive in its whistleblower enforcement under Section 105C of the Mine Act. A couple of things, and these are more, I guess, from a policy perspective, perhaps future legislation, depending upon what happens in the elections. But one thing that does distinguish MSHA from OSHA, many things too, but in this area, is that MSHA can hold individual supervisors and agents of management personally responsible if they engage in whistleblower retaliation. And they can be fined up to $74,000 under Section 110C of the Mine Act. So it is not limited to violations of codified standards. It also is extended to that. Now, the OSHA currently does not hold individuals responsible other than criminally under a narrow set of circumstances. But it would be interesting, I think, for the Department of Labor, which is the agency over both OSHA and MSHA, to perhaps take a look at the efficacy of enforcement comparatively under 105C versus Section 11C of the OSHA Act, and also determine whether that threat of supervisor culpability has been effective, perhaps in avoiding subsequent claims against an employer. So that's one thing to take a look at. I also wanted to express a concern that we have a huge gap where workers may be falling through the cracks in these protections. And I'm talking specifically about temporary workers, people in the gig economy, many of whom are part-time workers working multiple jobs where they don't feel secure or have status in any of them. And also workers, day laborers, for example, who are improperly being classified as independent contractors. In fact, some employers, and I hate to say this, represented some of them who tried this, calling everybody an independent contractor so that they could claim to have no employees and therefore not be under OSHA jurisdiction. And the Department of Labor obviously has just made some changes in how independent contractors are viewed versus employees. And while it's for purposes of the Fair Labor Standards Act, I am concerned that this is going to have a ripple effect down into OSHA protections. So I think it would be beneficial as part of their outreach efforts for OSHA to make it clear that not only is it a violation to retaliate against one of your own direct employees for protected activities such as raising a safety concern, but also, against someone who might be there from a staffing agency. If Mary raises a concern because she's not given PPE and she's from a staffing agency, and the host employer calls the staffing agency and says, don't send Mary back. Mary may not have any other jobs that she can be deployed to. She's lost employment, and yet she may be totally unaware of her rights under Section 11C against either employer. So that is something, because of the growth of the gig economy, or the fishered workplace for another term, that really needs to be addressed in a more satisfactory way by OSHA, in my view. I also wanted to note some concerns about whiplash in the policies that OSHA has been putting out relative to the whistleblower protections in Section 1904, which I talked about earlier, Part 1904, 29 CFR, and that's the electronic record keeping rule. But when it first came out in 2016 under the Obama administration, there was a position that, except for certain legal exemptions, the employer could not just drug test somebody because they were injured and then take a retaliatory action such as firing them as a result of that. And back in 2016, the take on it was generally that if you didn't have one of these other reasons to do the testing, such as reasonable suspicion, you couldn't test the worker. Unless you could articulate why you felt their impairment was a causal factor. That has been changed as of the 2018 memo that federal OSHA put out, and now it kind of shifts it back. And as long as you say you're doing it as part of a root cause investigation, you can drug test any injured worker. What I am seeing, again, as an attorney, mostly dealing with the employer community, is that we're back to kind of hunting for reasons to terminate injured workers, specifically drug testing, especially in states, and there's 33 of them plus DC that have medical cannabis. And a number of these situations have frankly resulted in people losing their jobs over CBD use because employers are using very low cutoff levels. That is absolutely going to have a chilling effect on workers coming forward to report injuries. And the whole concept here in enhancing these whistleblower protections under the injury and illness reporting rule was that the data that OSHA is compiling electronically and now is using as part of its site-specific targeting program is going to be reliable data. If you're cooking the books, and OSHA again changed its policy on incentive programs and on worker discipline between 2016 and 2018, all of it done in a way to insulate the employer from retaliation claims, but leaving the workers, in a situation where if they do report an injury now, they will lose a bonus under an incentive program. And OSHA seems to say, well, as long as you discipline workers for violating rules, we'll say that you have a good safety culture and this isn't really a problem. So I'm really hoping that OSHA takes another hard look at the changes they made to this policy and to consider returning to the original iterations on that. So to kind of wrap up here, I talked about COVID a little bit up front. Because there is no emergency temporary standard at the federal level, we need to articulate better what protections workers have about COVID. The Virginia ETS is pretty clear about what is protected, including things like social media. But in the absence of a federal OSHA rule, it's going to be difficult to determine if they raise a concern about COVID, what they are supposed to be adhering to. So, again, that needs to be clarified. A couple of final things here. I will wrap up. Consider more work sharing with the National Labor Relations Board, since safety and health is a term and condition of employment, and that would allow utilization of their 180-day statute of limitations. I know that there had been a work sharing agreement back under the Obama administration, but I haven't heard of that being used much. And when the whistleblower investigator with OSHA learns that the retaliation may be based in part on race or gender, giving the worker a heads up that they have 180 days to file a complaint with the EEOC would be beneficial as well. So to wrap up, I appreciate everything that OSHA is doing, but clearly it is stretched too thin and needs more money for its whistleblower programs, because not only is it enforcing worker rights under the OSHA Act, but also under a dozen or more environmental statutes, all of the DOT regulations and agencies, the Sarbanes-Oxley Act, and more. A private right of action, such as they have under the Mine Act, would be useful, because it's clear OSHA is not going to be able to do full investigations of all complaints, including many that are meritorious because of it being overwhelmed due to COVID-19. So thank you again for your consideration, and I will try to formalize my comments for the record.
Thank you very much. Operator, do we have anybody else?
Our next question comes from Melody Russo. Your line is now active.
Hello, my name is Melody Russo. I am a whistleblower investigator, and one of the things that I think is problematic for people who do whistleblower investigations and the people that manage them and manage the budget is having any kind of a metric that's valuable for caseload allocation across investigators, so that they can be adequately staffed up for the amount of cases that come in. Because the way things work where I am right now, the cases I inherited some when I started this job, more have been coming in, and they continue to come in, and so it's reaching a point where it's very difficult to do a lot of meaningful work before too much time goes by, and to catch up or resurrect some of the more aged cases to do anything with. And also, I'm with a state program, and we're graded by the federal OSHA, but the metrics that would probably be very useful to those in our Department of Labor would be having some guidelines for how many investigators they should have based on the number of cases that they have on hand right now, and that they apparently seem to be receiving, to get a better way to have a meaningful maybe turnover goal, because they do come in various shapes and sizes. And there's a lot of cases that come in from small business owners or small business employees. And the one thing that it's been a personal objective for me is to educate both employees and employers. I don't have a lot of forums to be able to do that, but I see a lot of gaps where within the whole of state government, and this possibly, mostly in the states, where they have business licensing facets of state government, so they're in touch with people who have businesses. More collaboration, active collaboration with the Department of Labor about the other requirements that businesses need to be held to and are held to, and then if they also are an employer, additional requirements, so that employers get more education about what it's like to operate a business and what some of these requirements are. Because quite honestly, most of them have no clue whatsoever, and feel that because that state is a right-to-work state, that gives them impunity at any time and at all times. So, I think that OSHA should have some goals of itself to have bench strength for investigator growth and development and recruitment to be able to implement a limit to the number of cases that an investigator or a group of investigators can meaningfully handle. And that's
Well, thank you very much for your comments. Operator, anyone else?
Our next question comes from Rich Hoffman. Your line is now active.
Yeah, just to finish up on being a victim of two separate retaliatory issues. When I worked in California, I actually graduated and taught my class at the academy, but not until on day 3 when I asked a battalion chief, a lead instructor, I asked a simple question: is not friction loss a direct mathematical function of gallons per minute? Now, the other 23 of my comrades had never been to college, let alone graduate top of their class in hydraulics, had a clue what I was asking about. But that battalion chief did, because in 1965 he had to learn it correctly. But since 1974, they had to calculate a new process to make it easier to meet the affirmative action goals by hiring enough women and minorities that they felt weren't smart enough based on skin color and gender, that they could actually do such an incredibly complex mathematical calculation process necessary to produce enough engine pressure to produce enough nozzle pressure to meet the NFPA 1002, which is a driver operator shall pump enough water pressure to produce an effective fire stream at the rated capacity of whatever nozzle he or she chooses. And what I've invented since then is a hydraulics calculator, not only a mechanical calculator that can do a 3-minute math equation in as little as 7 seconds, but also a phone app that's being released. It should be done this week after 2.5 years of development, and but it addresses this very issue. But when I confronted this battalion chief, who's got to get these meet the budgetary constraints of the missing portion of their budget from the federal contribution, from federal public funding, from every taxpayer across this entire nation, they decided that they were going to dumb it down. And now they pump 1/2 to 1/3 the water pressure at the engine, which produces like 20% of the nozzle pressure you need at the end of the hose lay. And back in the day, in the early 80s, when I was a firefighter, I was literally burned on every fire past 500 feet going up the sides of a mountain, in which I had no communication with the radio to my driver operator, because we had budgetary constraints. And but it wasn't until after 5 seasons of being burned that I got to the academy. And when I asked that question, I was told, "Mr. Hoffman, we know you know what you're talking about," in the most derogatory manner available. I was going to be president of the class. I had 11 confirmed votes. I'm a nice guy. I know my stuff and everything. And this guy then waited not 3 or 4 seconds, which is cruel, in a practical joke, to go longer than that time before cleaning it up. He waited 7 seconds. And let me explain something. You piss off your lieutenant, he'll write you up. You upset your captain, you'll be fired by the end of the day. You upset a battalion chief in that level, you will be escorted off the fire in handcuffs with law enforcement. Okay? And he screamed from the front of the class to the back class, "Do not confuse the class." Why? Because 23 of my comrades weren't yet educated in the necessity of calculating gallons per minute over 100 squared times the coefficient times the length of that you're actually pumping that water within that hose over 100 for every section of 5 different sections of a 1,000-foot hose lay, where you have the nozzle flow at the end of the attack line to protect us. And then you have a 10-gallon a minute lateral at every 200 feet thereafter to put the sparks out, so it doesn't jump the lines and take us out, jumping the lines 300 feet behind us. And now we have a wall of fire coming up our backside just outside our wet line that we're putting up the side of the mountain. And now we have to dive into the burn to save ourselves. And we have to have these laterals operating. And when you have 60 gallons a minute at the end of that hose line, imagine a tree with 4 branches. One at 200 feet, one at 400 feet, one at 600 feet, one at 800 feet. All those are flowing 10. Okay, 60 at the end of the hose line. From 800 to 1,000 feet, you're flowing 60. From 600 to 800 feet, you're flowing 70. That's 60 plus 10 has to flow to support both those nozzles. Then you flow 80, then 90, and finding 100 gallons a minute in the first 200 feet of the hose. And the CAL FIRE today teaches you do the entire hose lay at the flow rate of your attack nozzle only. Okay, they believe they can pump a 2,000 foot hose lay with 331 pounds of pressure. How do I know that? I graduated top of my class answering every question wrong, in order to graduate top of my class, 96.8%, to put food and shelter in place and health benefits in place for my family, my wife who's pregnant with my now son who is a now Navy pilot. Okay, I'm not some dumb ass that's fell off the freaking cart. The point is that they've been teaching this lie for 46 years. And when I asked that question, I was destroyed. And I had is my time up?
Yeah, Rich. I'm going to make a recommendation for you because you have so much to say. Really interesting comments. I'm going to remind you that you can send written comments.
Okay.
OSHA.dwpp@dll.gov.
Okay.
By the close of business on October 20th, and we will upload them into the record.
Okay, please. Okay. So just go to caextortion.com, CaliforniaExtortion.com.
Thank you very much.
Thank you.
Operator, do we have anyone else? Okay, I'm not hearing anybody. So here I'm going to remind you one more time. You may submit any additional written comments to OSHA.dwpp@dol.gov. We will be posting these into regulations.gov under docket number OSHA-2018-0005. Once again, I thank you for attending this call today. We really appreciate your input. And the operator, we thank you for your service.